The meeting of the Courts of Justice Subcommittee on Criminal Law will come to order. Members, if you please use the screen before you to enter your presence. That way we see it all working. It's working and everyone's here, so glad to see you. Clerk, please close the roll. Thank you. And again, because it's our first meeting, I just want to make sure that you meet our new clerk, who is Vaughn Anderson, or Aronson. Vaughn Aronson, who is our new clerk. Delighted to have you, Vaughn. And of course, we all know clerk counsel from the Department of Legislative Services, Troy Hatcher, and ably, this committee always has outside counsel because of the complexity of the criminal law, and that is Steve Mutnick. Pleased to have you all with us. Now, on the agenda before us, I will note that HB 1642 Hayes, which has to do with risk assessment using AI, that will be put off to our next meeting. It'll be on the docket for our next meeting. So therefore, we have 5 bills before us today. And is there anyone here, any patron here who's not on the committee? Yes, please proceed. Delegate Willie with HB 1568. Wiley, excuse me. I saw your mouth move. My apologies. I will say in some explanation, I think I was on the 3rd date with my husband before I understood that his name was Watts, not Watson, because you always slur Watts into the next word. So my apologies for that.
I don't know if this mic's working or not, but can you hear me? Everybody good? Yes. Good afternoon, Madam Chair, members of the committee. House Bill 1568, I did submit an amendment with a substitute, which I think should have been handed out, or it's getting handed out as we speak.
That's right.
I'll let you read that real quick, and I guess I'll need.
Is there a motion on the substitute?
Move the substitute.
The substitute is before us. If you will speak to the substitute, please.
Thank you, Madam Chair. So this substitute, quite simply, grants law enforcement officers of Frederick County jurisdiction over offenses committed in the city of Winchester within 1 mile from the county line. I think we adjusted that county, the wording in terms of the 1 mile rule to be amended accordingly based on what's in front of you with that substitute. The sheriff asked me for this action to be taken so that he can perform his services in the county-related buildings in the city.
So as I understand the substitute before us, it's significantly different from the bill that was introduced, which it would have been any crime anywhere committed in Winchester 1 mile from the limits. Now it's only in buildings owned or occupied by Frederick County.
Correct. Yes, ma'am.
If I could proceed with question, does that mean that that also includes anything that might be owned by the state, and what is the status of your judicial buildings?
So the way I understand it, and we've worked with the Commonwealth Attorney in the city, is that it's only county buildings.
Okay, only county buildings.
Yes, ma'am.
All right. Are there any further questions on the amendment, on the fact that it is shifting from such as we had on the books from the 90s with the Richmond area where it was any crime to being just those crimes committed in buildings owned or occupied by Frederick County, and that would be wherever they exist in Frederick County? Any other? If not, a motion, all those in favor of adopting the substitute say aye. Aye. Opposed? Okay, now the substitute is before us. If you would, do you have anyone here to testify?
Not that
If
I'm
you
aware
would
of.
like to, the normal routine will be before we take a vote, you always have the final word. So if you'd like to again explain to the committee why this bill you brought before us, what was the ask from the Frederick County, Winchester area?
So the sheriff's department in the county, with the county-owned buildings in the city, they were having issues with some of the meetings they were holding, with some of the, how do I say it nicely, with some outcry from citizens, and some of the meetings weren't being controlled correctly, and there wasn't a way for him to enforce or to handle these meetings. So he asked me kindly to carry this bill so that he can perform his services for those meetings and other related safety needs in those county buildings.
Thank you. Are there seeing no questions from the panel? A motion is in order.
Move to report. Second.
It has been moved and seconded that we report the substitute for HB 1568. And no further discussion. Clerk, please open the roll. Please cast your vote. Seeing that all have voted, HB 1568 with substitute reports 8-0.
Thank you, Madam Chair. Members of the committee, have a good day.
Delegate Wiley.
Thank you. Yes, ma'am. Thank you.
Is there any other patron in the room not on the committee? Seeing none, we'll just go in the order of the agenda. Is there anyone who has to go to another committee meeting? I think we got one, two, everybody does. Okay, Ren, I think you actually are with us, so I'm going to jump down to Delaney as being the next one. HB 1734, having to do with the naming of the sex trafficking response coordinator and the use of the term trafficking.
Thank you, Madam Chair and committee. It's good to see everyone again. So HB 1734, I think it's a pretty technical fix that aligns with what we're seeing in practice. It changes the name of the sex trafficking response coordinator to the human trafficking response coordinator. The Code of Virginia establishes the position of sex trafficking response coordinator within the Department of Criminal Justice Services, and as written, the law designates the duty of the coordinator that are specific to sex trafficking. However, legislation passed last year defines criminal labor trafficking within Virginia's law. So with the introduction of this law, it's especially important that DCJS be able to continue to provide labor trafficking training for law enforcement, prosecutors, and victim services. And this bill updates the title of this with current practice at DCJS.
Thank you. Are there any questions of Delegate Delaney? I should have asked this, as I will try to do routinely on every bill. Counsel, do you have anything to bring to our attention? Okay. Is there anyone here to speak for HB 1734?
Good afternoon. I'm Tracy Jenkins with the Department of Criminal Justice Services, and we strongly support this bill.
Thank you. Is there anybody else? A motion is in, or if there's no further discussion, motion in order.
Second.
It's been moved and seconded to report HB 1734. Any further discussion? Seeing none, please open the roll. Please cast your vote. All have voted, and HB 1734, we recommend reporting by a vote of 8-0. Okay. The next one then, not seeing Delegate Bulova here. As soon as Delegate Bulova comes in, we'll recognize him. But right now, I'm going to just drop down to the next one and then back up to Delegate Williams. 1757, Hernandez, if you would please present.
Thank you, Madam Chair. It's good to be back for the 2025 session. So this is HB 1757, and this bill simply seeks to clarify that indigent defendants should be assessed the same legal fees for their representation, regardless of whether they are represented by court-appointed counsel or public defenders. And this clarification is needed because of the interplay of two bills from last year's session. One of those bills was HB 102, patroned by Delegate Reeser, and that bill limited fees for court-appointed counsel representation. Happily, that bill was signed into law. And then there was a second bill last year carried by Delegate Cousins that did a number of things and had, as one of the things that it did, a sister provision that limited fees for public defender representation. That bill was vetoed. And so we have been left in the law with something of a disparity that raises constitutional concerns, raises concerns about equal protection violations. And so this little bill just remedies that disparity. I don't think that the result that we were left with last session was intentional, but we do need to correct it. We've worked with the Office of the Executive Secretary at the Virginia Supreme Court. This is also a recommendation of the Indigent Defense Commission. So happy to take any questions. Hope it will be the will of the subcommittee to support the bill.
Thank you for that excellent overview. Are there any questions?
Madam Chair,
Yes, Delegate Williams.
for the patron, do you know the fiscal impact of this bill? Do you have a fiscal impact?
Madam Chair, I reached out to OES and some of the advocates. We do not think that there will be a significant, if any, budget amendment that's required here. I did submit a placeholder just so we could go through the process of $50,000, but it should be minimal, if
So
anything.
at this time, there is no impact statement.
That's right.
Thank you. Further questions? Counsel, do you have anything to bring to our attention?
Madam Chair, I don't want to steal the thunder of the people who are staying there, but I think to answer Delegate Williams' question, there is no fiscal impact because it was assumed that this was already part of the budget, because it was assumed that this was just a simple language where we put the word article instead of chapter, or put the word article instead of chapter, and so it was, I think, assumed that this would already go into place.
Delegate Williams, does that cover what your concerns were?
No, that's okay.
But, okay, so again, it was assumed in the budget, all right. Are there any further questions from the committee? Anyone here to speak for the bill?
Good afternoon, Madam Chair and members of the committee. Allison Powers, the Director of Policy and Education at the Indigent Defense Commission. I want to thank the patron for carrying the bill. This is a commission bill, and the patron has explained it quite well, and I'm happy to answer any logistical questions, but this is a fix that OES, I think, will speak to as well, and supports, and is what is being contemplated in the statute already. So this is just a clarification.
Thank you.
Eileen Longenecker with OES at the Supreme Court. We believe this bill provides some necessary clarification. It aligns with current court procedures, and for the reasons already stated by counsel, we don't believe there's a fiscal impact.
Thank you.
Brad Haywood, on behalf of Justice Forward Virginia, we support the bill.
Thank you.
Madam Chair, Mark Dix on behalf of the Virginia Trial Lawyers Association, and we support the bill.
Thank you. Is there anyone here speaking against the bill? Okay, Delegate Hernandez, you have the final word before we move on the bill.
That's all I've got. Hope it will be the will of the subcommittee to support the bill.
All right, thank you. A motion is in order.
Second.
It has been moved and seconded that we recommend reporting HB 1757. Any discussion of the motion? If not, please open the roll. Please cast your vote. Seeing that all have voted, close the roll. The vote is that we recommend reporting HB 1757 by a vote of 7-1. Okay, the next bill, then not seeing Delegate Bulova in the room. Delegate Williams, you're on. And I'm sorry, Delegate Williams' bill is HB 1553.
Thank you, Madam Chair. Thank you, committee. This bill is pretty simple. It removes the requirement that a copy of a notice of appeal to the Court of Appeals in a criminal case be mailed or delivered to the Attorney General. This is causing redundancy that is not necessary and confusion in the AG's office. With the change, you used to have to submit a notice that the case had been appealed directly to the AG's office, but now there's a delay in the deadlines that are in place now, so the AG's office doesn't need to have notice until jurisdiction is changed from the lower court to the Court of Appeals. That's when the AG's office becomes counsel of record. So that's what the bill does.
So my clarification, it's not just a matter as in the summary of what form notice takes place. In fact, what this bill does is say that the AG's office does not need to be noticed.
Yes, ma'am.
Thank you. Are there any questions of the patron? Counsel, anything you wish to bring to our attention? Is there anyone here speaking for HB 1553? Anyone speaking against? Okay. You have the final word, Delegate Williams.
I just ask that we pass this bill and report it to the next committee.
Okay. Thank you. Hearing no further discussion, any questions? Last chance. A motion is in order.
Move to report.
Second.
It has been moved and seconded that we recommend that HB 1553 be reported. Please open the roll. I'm sorry, any discussion of the motion? Open the roll. Members, cast your vote. Close the roll, and we recommend, the vote is that we recommend reporting HB 1553 unanimously by a vote of 8-0. Okay, I know that when I spoke with Delegate Bulova, he expected to be here at 2 o'clock. So if you don't mind, it's 5:02. If we could suspend, and if anybody knows how to get a hold of Delegate Bulova, I know he's tied up with appropriations, that would be greatly appreciated. And Delegate Bulova, if you can catch your breath. We are ready to hear HB 1711, which has to do with the Mass Violence Care Fund being established.
Marvelous. Thank you, Madam Chair. And I'm not sure if the mic is on, but thank you, Madam Chair, members of the subcommittee. As you said, this is House Bill 1711. The purpose of this piece of legislation is to formalize in the code the Mass Violence Care Fund. Just by way of background, the 2023 Appropriations Act included $10 million in general funds for the purpose of being provided to victims of mass violence. However, at the time, the details of how that would work needed to be worked out. And so as a result, the Act directed the creation of the Mass Violence Fund Work Group to do a couple of things. So first of all, to define a mass violence event, to define mass violence victims, and then to make recommendations on the structure of the fund, what would be eligible for reimbursement, how it would relate to the Virginia Victims Fund, and then also how disbursements would be made. It was a very highly collaborative effort and included representatives from the Department of Criminal Justice Services, the Virginia Victims Fund, the Department of Planning and Budget, the Retirement System, the Virginia Tax Victim Family Outreach Foundation, the Department of Treasury, and also staff from House Appropriations and Senate Finance and Appropriations, along with several others. The work group worked for about a year and then finally delivered its report on October 1, 2024. And House Bill 1711 reflects the outcome of the work group's deliberations. Just in terms of the basics, the purpose of the fund is to reimburse victims of mass violence events for out-of-pocket expenses related to physical health and mental health that aren't covered by other means. And so that includes things like private insurance, includes the Virginia Victims Fund. In putting together the report, the work group identified several gaps in current coverage that the Mass Violence Care Fund was meant to address. And so two key examples. The Virginia Victims Fund has a lifetime cap on certain reimbursements. It has a particularly low cap for coverage on psychological and emotional injuries. In addition, the Virginia Victims Fund has a cutoff of 1 year for filing. The Mass Violence Care Fund, by contrast, you actually can't even apply for it until 3 years after that mass violence event. And so I think as everybody here understands, sometimes it takes a while for the mental health impacts and PTSD associated with a mass violence event to start manifesting itself, and that can happen over multiple years. And so this is meant to be able to wrap around with respect to those long-term impacts. Access is only granted to the Mass Violence Care Fund if other means are have been exhausted. So in that way, it builds on and supplements the Virginia Victims Fund as the resource of last resort. In looking at the definitions of mass violence, there is no universal definition as such. Virginia is actually the first state to set up such a fund like this, but the work group strove to keep this as broad as possible. The definitions chosen were crafted after reviewing definitions from the Secret Service National Threat Assessment Center, the Bureau of Federal Investigation, and the U.S. Department of Justice Office for the Victims of Crime. As far as some of the other mechanics, just really quickly, so it has been capitalized at $10 million. That was already appropriated, and this will be a separate non-reverting fund. Disbursements from the fund will be in terms of the amount of interest generated from that capital investment. So you've got the $10 million. The amount that will be available each year is the interest on that $10 million. Investments will be made by the Department of Treasury. And then finally was the question of who's going to administer the fund, and in this case it's set up as a sub-fund of the Virginia Victims Fund, which is part of the Workers' Compensation Commission. That made most sense since they've already got direct experience in this area, and so there's also means that they're able to go ahead and mesh together well. So again, Madam Chair, I wish we didn't have to have a mass violence care fund, but I'm glad that Virginia is leading the way towards helping those who have been victimized and traumatized by mass violence. And so happy to take any questions. Several of them might require phoning friends, and so we do have representatives here from criminal justice as well as the Virginia Victims Fund who could go into a little bit more about the thought process in terms of the mechanics of how this would work.
Thank you, Delegate Bulova, and thank you, too, for reaching out to me last night to begin thinking about this. So I'm going to pose these two basic questions for council or for representatives of the compensation fund to clarify. What concerns me is on lines 21 and 22, as in the first question is, as we look at intentional criminal event, how is it typically determined by the Victims' Compensation Fund that that has occurred? Is it an arrest? Is it a trial? Does it wait until appeal? We've seen all kinds of definitions, depending upon the area of the law that we're talking about how you define that, in fact, an intentional criminal event has occurred and now you've got people qualified. And then the second issue that I would like to have addressed is the term physical injury. While I know the work group came up with using the term physical injury, many years ago I got involved, and it's probably still somewhere in my files, when you word search 18.2, you get all kinds of use of words of serious bodily injury, and often it's bodily injury I've now lost, but I would say at that time there were about 6 different references to injury, none of which was consistent. So seeing physical injury, I looked that up on the code last night in 18.2 and see very little reference that uses physical injury. So for council, I would particularly welcome any recommendations about whether or not, in this case, the open door physical injury, which, when we talk about assault and battery, could just be touching, whether or not, in this case, when it comes to the definition of mass violence event, touching is still okay. But those are the 2 areas that, as criminal law subcommittee, as opposed to all of the funding of this, which you all have done up in appropriations, are what I would like to see resolved. So having said that, shall we start with intentional criminal event and some background from the compensation fund of what usually triggers your determination that there has been an intentional event that is, in fact, criminal?
Good afternoon, Madam Chair and other members of the committee. My name is Shannon Dion. I am the director of the Virginia Victims Fund, which is officially known as the Criminal Injuries Compensation Fund, which is a program run by the Virginia Workers' Compensation Commission. With regard to the chair's question about intentional criminal act, we typically look for a police report to establish that a crime has been committed.
Police report. Are there any questions on that answer? So this has been the typical way in which the fund has been administered over the years?
Madam Chair, yes.
Thank you. Council, any questions on that point?
Madam Chair, the only thing I was going to answer that's probably how they do it, because the term in the CICF Act is act committed, and so that obviously doesn't require a conviction. That does not appear in this statute. It just says an intentional criminal event resulting in physical injury, but I think that the word committed kind of gets you to that point of it doesn't require even a charge, just as she said, a police report.
So it's charged police report, and you're comfortable with that being implied within this wording. All right, then the other question is the issue of physical injury. I assume you were on the task force. What were you really thinking of in terms of physical injury?
Madam Chair, I don't think I can speak for the work group, but I can say, as for the Virginia Victims Fund, physical injury, we looked for medical records to substantiate a physical injury.
Okay, medical records. Council, is physical injury cover that kind of a limit of what you're really looking for, or do you have any other suggestions?
Madam Chair, I think that again, we look back to the current law, and that is the same language that's used in 19.2.368.2, which is the current CICF law, so I don't see an issue with using that again as to the defining physical injury. Now, and I think, obviously the bill itself requires the commission, and I'm sure Ms. Dion to have to come up with the regulations that define these even further.
So would you repeat again, 19.2, what was the code section referring to physical? I'm sorry, but there's an audio problem that I have in this room, so.
It's 19.2.368.2. 368.2,
okay.
which is the definitions for the original criminal CICF, I'm old enough to know that.
So there's
refer to it as that instead of the
consistency
victims, the Virginia Victims Fund. So that's already used physical injury. And so there's a definition that's already been set by the CICF for that. So I don't see an issue there. There's one point I do want to bring up when we get to that.
Thank you. Thank you. Are there other questions? Yes, Delegate Williams.
Yeah, question for council. Is this the first time we're defining mass violence event in the code? Do you believe?
In this way, yes. There are certain events that we don't use the word mass violence event, but there are certain areas of the code where large criminal acts are defined in certain ways, like the aggravated murder statute, the gang violence statutes, that usually require, I think it's still 3 or more people involved or victims involved in most every statute. I know with aggravated murder, it requires 3 or more victims.
Question for the patient.
Yes, please.
Have you thought about the 3 or more piece of this? Because as she talked about assault, somebody could run through here, smack 3 people and leave, and that's a mass violent event.
Yeah, I guess, Madam Chair, I would rely back onto the work group, again, which took a look at the definitions that were out at the federal level. I forget exactly which federal agency had already set a number, but that is something that's reflected at the federal level. And I don't know, Shannon, if you know in particular or can stall while I look that up.
Yes, sir. For the Virginia Victims Fund internally, we already label any incident that results in 3 or more victims as a mass violence event.
So you have had that precedent for some time?
Yes.
Delegate Williams? Okay, I also, Delegate Boulevard, both of us are night people, so he also linked me to the report, which I glanced at, and on page 17, it says, this is the task group reporting. And they said mass violence and mass violence event are defined differently by various entities with some common elements. A definition of a qualifying event should be used to ensure clarity for victims and potential claims under the Mass Violence Fund. Therefore, we see then a specific definition based upon that observation before us, rather than just using the words mass violent event, and that's what they're putting into code, is that specific 3 or more people, which I understand there's precedent for that standard. Are there further questions?
Madam Chair.
Yes, Delegate Batten.
Question for the patron. So I understand that this is a sub-fund, and I guess my question is about the expense of administering the program. So I see in here that there's a public information program that is established, and I think the Ombudsman also has hiring authority as well. So I'm just curious about if this could be an overall sort of a depletion of the funds available to victims just due to the costs of administering another sub-fund. Can you speak to that?
Yeah, Madam Chair, and I recognize that was a part of the, I think it was a part of the work group's work that was not particularly completed in terms of how this would be administered and how that cost would be handled. I think we're cognizant of making sure that we're not eating into the sub-fund. I do think that you're going to have some administrative efficiencies by the fact that we have paired this up with the Virginia Victims Fund. But that's probably something that we'll need to tackle when I assume this goes up to appropriations to ensure that we're making whole the administrative part of the process.
Thank you. Are there any further questions? Is there anyone here speaking for the bill who would like to speak for the bill? Please come forward.
Madam Chair, members of the committee, I'm here today, Andrew Goddard, as a private individual speaking as the father of someone who was survivor of a mass incident in Virginia. As you may know, surviving such an incident is just the first step on what can be a lifelong journey of medical, psychological, and financial problems. My family was very lucky in that my son's injuries, though they're quite substantial, and continue to this day because of lead poisoning were covered in a special agreement between the state and all the families of that incident. But I recognize that there are other families that don't have that coverage, and this would definitely cover those families and their long-term effects of being involved. But I would be remiss if I didn't point out, if anybody's concerned about the fiscal impact of such a thing, if there was bipartisan support for preventive measures that would stop mass incidents from happening in the first place, that would make the money unnecessary. But in my 18 years of being here, I have not seen bipartisan support for preventive measures. And I find that very difficult to swallow. Thank you.
Thank you. Are there any other speakers for the bill? Is there anyone here speaking against the bill? And we also have one speaker online. If you could please bring on Joseph Samaha. 2 minutes, please. When you start. Joseph, welcome. And you need to be on camera if your reception allows that, so that we're able to see who's speaking. Please proceed, Mr. Samaha.
Yes, good afternoon, and thank you, Madam Chair, and all of the delegates and sponsor Bulova for hearing this bill today. And I do reiterate what Andrew Goddard just spoke of. Being a father of a victim of the Virginia Tech shooting in 2007, the families have formed a foundation around that tragedy to address the long-term needs of mass violence victims in Virginia and around the country. We very well understand that there is always immediate response and financial assistance available for those that have been impacted, families and survivors, and those that have been traumatized and uninjured by these events. But no one does have a plan for their long-term care, at least a sustainable plan for a long-term care, financial care for those that have been impacted. We see the necessity for this because in our outreach to other families and survivors, we understand that after year 2, with all the good intentions of the criminal injuries compensation funds, they are limited, they are restrictive, and we need to cover the gaps for financial care. That insurance does not cover, again, in the long term. So many are still suffering from those impacted in Virginia, from the Virginia Beach shooting, from the Chesapeake Walmart shooting, from the University of Virginia shooting, and those folks have not been helped and assisted for their long-term care needs. And this model, that we are proposing within the bill, the $10 million fund, is a sustainable and practical and actionable way to address this. The funds, as we know, are not dispersed, but they are invested by the state, and we have other states that are also following suit with this model as well. That'd be Maine and New Jersey, to name 2.
If you could wrap up, please.
Again, yes, this is something, again, that we find that the committee would pass on as a proactive and practical solution to those needs of those folks that are still impacted financially.
Thank you. Thank you very much, Mr. Samaha. Are there questions?
Thank you, Madam Chair. Question for the patron, and more of a practical question. Let's say there's civil litigation that's going on to recover, among other things, medical expenses that takes a number of years to work its way through the court system. How do you think that would work with the sort of 3-year provision that's in your bill? Would you want potential applicants to wait until the resolution of litigation, or sort of what would be a best practice do you think, as it's written right now?
Yeah, so thank you, Madam Chair and Delegate Hernandez. My understanding of the way that this works is that you do have that 3-year window before you can apply, but that it is meant to be a means of last resort. And so if there's active litigation going on, that you would wait to see if that backfills. I don't know if Shannon, I think that's how it works, correct? Yep.
Madam Chair, I can tell you that for the Virginia Victims Fund, that claimants do have to exhaust all collateral resources, including civil lawsuits. So we typically would wait until the outcome of that to see if they received any benefits that pertain to things that the fund would pay for.
Follow up, Madam Chair. So then that would be when you receive a claim, you would go through a process to ask them at the outset whether all legal remedies have been exhausted, and if so, then you would proceed as appropriate.
Yes, for the current claims, I don't necessarily see language in this bill about that.
Any further questions? No. Any questions from other members of the committee? Counsel, did you have anything that you wanted to add?
Yes, Madam Chair. Madam Chair, I'm looking at line 29 in the definition of victim of mass violence, and when I first read this, I thought there was a word missing because it seemed like as a result was a pretty wide and broad definition. Somebody could suffer emotional injury as a result of mass violent events that they watched on TV and weren't direct victims of. And I looked into the Virginia Victims Fund language, and the word direct appears in front of the word result in that definition of victim. And so I would suggest that we insert direct on line 29 after the first two words as the direct result of a mass violence event, so that it can be administered in the same way that the current Victims Fund is.
Madam Chair, I would take that as a friendly amendment.
Friendly amendment. And if you could repeat the amendment again, it's starting with line?
Line 29, after the first two words, add the word direct in front of the word result. So it would read, victim of mass violence means a person who has suffered physical, emotional, or psychological injury as the direct result of a mass violent offense.
Is there a second? Okay. So it is, all those in favor say aye. Aye. Opposed. Okay, and I should have said this in discussion. Again, the victims' compensation always also extends to direct family members. Correct. So that when you say direct result, because you've already talked about the fact that family members qualify, that doesn't change in any way that practice of extending it beyond a person who was directly injured. Yes, okay. Then now we have the bill before us as amended. Are there, I think we're ready
Madam
for
Chair,
any, pardon? Yes.
May I, and I think Ms. Dion said this when she answered the last question about the civil remedies. This statute only has that you have to exhaust all of your remedies under the Virginia Victims Fund. And I think she made the comment that it does not say you have to exhaust all other remedies before applying to this. It only says that you have exhausted all the Victims Fund remedies. So I don't know if, as to Delegate Hernandez's question, whether or not, I'm sure they could regulate that, but under the statute, I'm not sure it covers those civil remedies.
We have time if you would take a moment to look carefully at that language. Are you comfortable with and what that means as written versus the question raised?
So I can tell you that the Virginia Victims Fund, Madam Chair, does require claimants to exhaust those civil remedies, and then we take that into account. I do not see any language in here other than in section D, which is on lines 54 through 57, which says that expenses shall be made to a victim of a mass violence if all awards to which such victim or family household members is entitled to receive under subsection E, which is the Virginia Victims Fund award section are exhausted and at least 3 years. So perhaps council can shed light on whether both those things are necessary in order for anyone to receive funding.
Council, please.
I think, Madam Chair, I think that it is, both of those things are necessary, that have to exhaust all remedies under the Victims Fund, and that 3 years have passed from the date of the event. What I'm not sure, which I don't think this says, and I looked into the Virginia Victims Fund statute, and there's no requirement in the statute, the original Victims Fund statute, that remedies be exhausted. I think that's a rule that the Victims Fund has come up with. And so certainly they can do the same thing in this statute. My worry is that, you know, we may want to put language in there if, in order to say all remedies, let's see, receive under all awards and other legal remedies have been exhausted. All awards and other legal remedies. So I think there may be stronger language. I'm not sure that it's fatal to the bill to say that that the Victims Fund couldn't just regulate that rule. So I think it depends on whether we want to make it clear in the statute or leave it to the regulations.
So if I understand your question correctly, you're trying to make sure that the same requirements will be made of an individual, that they exhaust all possible compensation for what they're dealing with before they go to the compensation fund that would give them necessary relief. So he's wanting to make sure that you still want that qualification as part of the process as it's written out here now in code rather than practice.
Madam Chair, we take no position on the bill, so we will do as the General Assembly instructs us to do.
Well, we're trying to get it right, and I think on this one, there's not.
So, Madam Chair, and for council, I'm just trying to figure this out. If you've already exhausted all your remedies under the Virginia Victims Fund, wouldn't you have already exhausted your opportunities with respect to civil litigation and other legal remedies? I'm just wondering if we've taken care of it by saying you've had to already have met all the Virginia Victim Fund requirements, and then this is your thing of last resort. And so assuming the Virginia Victims Fund includes all those things, this truly just is the last piece of that.
I think by administrative rule, yes. I think the question is, do we want to put that in the statute or to leave that to the DCJS and the Victims Fund to make those rules?
Right.
And I think in addition, you know, and this may be my unfamiliarity about the nuts and bolts of how they work, but if somebody would apply to the Victims Fund and not get an award, then they could say that they've exhausted all of their awards from the Victims Fund, and then say they don't get an award because they're in the middle of civil litigation. So now I've exhausted all of my awards for the Victim Fund because I'm not getting one. I'm going to come to this one, and there's no requirement that I finish my civil litigation.
Delegate Bulva.
And I guess, Madam Chair, once we get 3 years out, there's usually going to be lots of mitigating factors that might have kept you from getting the care that you ultimately need. And so I think to the degree that we've left maximum flexibility for the Virginia Victims Fund to develop those guidelines, perhaps that might be the best way to approach this. And I think we do have it so that they can go ahead and develop guidelines. And if we need to add something in the code, that might make sense. But the enactment clause does give them the ability to put together guidelines.
Councilor.
And Madam Chair, I absolutely agree with that they can regulate this rule if they wanted to. My point was more, do we want to put it in the statute or leave it to them? And I think it really could be fine either way.
So then you're referring to our second enactment clause, which says you shall establish guidelines. Still with this dialogue, I would make this comment as chair. It's always been concerning to me when these sorts of things just end up being resolved in budget language rather than within the code. And particularly in this area where you have victims and victims' families desperately looking for help, as we heard from the two people who testified of what these families go through, that what we have in the code is proper guidance, that they're not expecting something that, in fact, somehow there's a loophole. So having said all of that, my observation is that while originally I've not been instructed to recommend reporting and refer to appropriations, now with this dialogue, I'm comfortable in that if we send you a bill, that the language gets resolved in the bill so that it's in code language so that the public easily can look at the code language rather than having to search through budget language for that resolution. So that's a general observation as a possible motion that we will be making. And of course, you have the final word on the bill before we take any action. Are there further questions, comments? Delegate Bulova, you have the final word on the bill.
Madam Chair, all I would say is I appreciate the dialogue very, very much. Understand and appreciate deeply your point about making sure that changes are in the code. And I think the only thing we'll be talking about at appropriations is, again, how to make sure that we're administering the fund properly, and always appreciate your thoroughness, Madam Chair, and anybody who can cite the language from page 17 definitely didn't just scan the report. So anyways, thank you, members of the subcommittee. I appreciate your consideration.
I go off my formal role by saying Delegate Bulova and I have always been sort of within eyeshot of each other. So late at night, we sort of race as to who will still be there when the other one leaves. But we share popcorn, so this also makes up for it. Having said that, I will also say before we act on the bill, if council does have any wording upon reflection that you think would clarify the language under D, that would be much appreciated. We may or may not act on it as before it gets referred up to appropriations, but if you could keep in touch with the patron, that would be excellent in offering possible clarity. Having said that, a motion is in order.
So move to report as amended and refer to appropriations.
Second.
It's been moved and seconded to report as amended and refer to appropriation. Is there any comment on the motion? I do want to make just a personal comment to those two individuals who testified. Ever since Virginia Tech, every time I pull into the main subdivision street leading to my house, I see the little memorial to Mary Reed, who had been the band captain in Annandale High School and lost her life in the first year in Virginia Tech. So I do understand, as we all do, that ongoing pain, some of which can be mitigated through this Victims of Violence Fund, and thank the patron for bringing it forward. Clerk, if you open the roll. Members, cast your vote. Close the roll. The HB 1711 has been recommended by a vote of 4-3 to report and refer with amendment to appropriations.
Thank you, Madam Chair, members of the subcommittee.
Thank you. Having no other further bills before us, we stand adjourned.